Okay, we're going to get started today. I think we are recording, and I want to welcome everyone to the New Mexico Family Advocacy Program's 44th ECHO session. NMFAP is a model of respondent parent representation being implemented in the 11th, 13th, and 2nd judicial districts. The program utilizes interdisciplinary teams of lawyers, social workers, and parent mentors working effectively together to provide quality representation and the advocacy and support families need for reunification or other preferred outcomes in the child welfare system. My name is Andrea Gunderson. I'll be the facilitator today, and we have IT support today through Jen Vieira. Today's topic is out-of-court advocacy for building individualized treatment plans. So that we know who is with us today, please enter your name and email address in the chat. Please fill out the post-session survey, which is an integral part of our program's data collection efforts under the federal grant. The survey will take only a few minutes of your time, and Jen will post the link to the survey in the chat box. 1.2 general continuing legal education credits will be offered to participating attorneys by our sponsor, the Corinne Wolf Center for Child and Family Justice. The CLE form can be found at the NMFAP ECHO Resource Library on the NMFAP website, and Jen will also post a link to that. One continuing education unit will be offered to participating social workers. Please email echonmfap@gmail.com by the end of this month, the 31st of October, indicating whether you wish to receive this credit. The presenters that we have today are Zabrina Aleguire, the co-founder and external executive director of the East Bay Family Defenders, and Arielle Reisman, senior social worker at the East Bay Family Defenders. Arielle is a licensed clinical social worker committed to helping families unite. After graduating from Occidental College with a BA in sociology, Arielle worked as a criminal defense paralegal, assisting clients who had faced tremendous adversity and trauma throughout their lives. This experience deepened her understanding of the inextricable connection between systemic oppression and justice system involvement, and inspired her to pursue a master's degree in social work. At New York University, she supported women arrested on prostitution charges as an intern at Women's Independence, Safety, and Empowerment, or WISE. She then worked as a case manager at the Community Assessment and Services Center, a wraparound re-entry center for adults on felony probation in San Francisco, helping clients to successfully transition back into the community. She most recently worked as the lead clinician for Community Works West's One Family program, providing family strengthening services to incarcerated parents and their children, and ultimately reducing recidivism. As the senior social worker at East Bay Family Defenders, Arielle works with and on behalf of parents with trauma histories, disabilities, and systemic barriers as they navigate the complexities of the family regulation system and fight to reunify with their children. Zabrina co-founded East Bay Family Defenders to elevate parents' value, expertise, and involvement in the most important decisions affecting their children's lives, the family and home in which they are raised. Zabrina has represented hundreds of parents and children in the child welfare and family regulation system. From practicing for over a decade in New York City at the vanguard of the creation of model family defense organizations, Zabrina set on a course to bring an interdisciplinary family defense organization to the San Francisco Bay Area. East Bay Family Defenders, or EBFD, pairs specialized attorneys with peer parent advocates and defense-oriented social workers to address the root causes of system intervention and support families to bring their children home. EBFD's model reduces family separation, mitigates the impact on children from placement into foster care, and promotes community-based support to strengthen families. Zabrina previously led a successful reform effort to improve protections for adolescent parents in foster care in New York City. She has co-authored several publications and practice guides, including on legal issues affecting foster youth, as well as protections for children when police arrest their parents. Zabrina taught juvenile law at University of San Francisco School of Law for 3 years before founding EBFD, and she is an NACC certified child welfare law specialist. There are several learning objectives that we have today, and participants at the end of this will be able to identify at least 2 ways that defense-oriented social workers are able to quickly build rapport with clients. They will be able to identify at least 2 strategies for conducting client assessments with an eye toward developing a legal strategy. They will be able to identify at least 2 ways to create client-centered and case-directed treatment plans by working collaboratively with the client, legal team, and county social worker. And they will be able to identify at least 2 ways collaboration between the client, legal team, and county social worker can increase client engagement. I will announce a reminder at 1:25 so that people going back to the ICWA Summit training can jump off and get on. But otherwise, our session here will end at 1:45. And with that, I will hand it over to Arielle and Zabrina. Thank you, guys.
Thank you so much, Andrea. It is really nice to be here with all of you today. It is quite an honor that Leslie invited us to share about what we have been exploring and sort of studying in a way in our practice at East Bay Family Defenders. This is shortly after the 3-year anniversary of our whole staff starting, or a founding staff starting, of which Arielle was a founding member and has really built our defense social work program at East Bay Family Defenders. So it's nice to be co-presenting with her today as a sort of a culmination of what we've been up to. So I'm going to share a link with you all in the chat, which is a study that has guided our work that I'm just going to mention. And then I'm also going to do a screen share. So if you just bear with me while I get this going. Yeah. And I wish we could go around and meet each of you. You'll have to forgive our brevity for the sake of making sure that we convey as much content to you as possible. And we will have some time afterward for discussion. So once again, I'm Zabrina, and I'm joined here by Arielle. And what I would like to say is that as a family defense attorney, both when I was representing children previously, and then also in my work representing parents, it has been a vital partnership for me to have working alongside me a trained social worker who was really just as dedicated to working with parents as I was. And so, you know, I will just share candidly that when I first became an attorney and was working at Brooklyn Family Defense Practice, I learned so much on the job from our social work director, Gittel Kagan. And she would like literally assign me parts of the DSM-4 at that time to read when I would be working with a client who manifested particular traits or characteristics. And the coaching and also joint meetings with clients that I had with social workers made me such a better lawyer for parents in particular. And so it has been such a crucial part of my foundation as an attorney in this field that it was really important to me when we started East Bay Family Defenders to both have social work and parent advocate staff, which had been the other crucial pillar for me of being able to do this work well with parents. So we have also, our founding parent advocate is still with us. We have a second one now, and Arielle works very closely and intricately collaborates with them. So, you know, the reason I put the article in the chat was to, you know, make sure that you've all seen it and to, you know, just highlight that interdisciplinary model that I began working in Brooklyn with parent advocate and social worker alongside lawyers was deeply studied in the most comprehensive and rigorous research done in this field around lawyering. And this interdisciplinary type of defense indeed is associated with with higher rates of reunification with parents, with speedier rates of reunification, also with speedier permanency for children who are not able to return to their parents, and with no increase in reentries into the system from those efforts. And in fact, there have been some studies that indicate less reentry into the system as a result of this model. Studies in Washington and Oregon have highlighted that. So I guess with that, I will really start to pass it over to Arielle, but I do want to just sort of give some experience from the field. Some of you are already working in this interdisciplinary model, so you may have already picked up on this, but what we have found in our experience, for what that is worth, is that in particular, the social work and attorney collaboration is crucial when there are clients who are really struggling with accepting or engaging in their case plan. And also when parents are having a hard time connecting with their attorneys or trusting their attorney. And also when the parent is having a difficult time establishing a working relationship with the department and the agency caseworker. So those are kind of the three guideposts we would provide. And Arielle is going to get into a lot more detail about tailored referrals, and we'll talk you through collaboration, lessons learned, and we will look forward to some discussion at the end. So with that, I will pass it over to my wonderful colleague, Arielle, so you can hear about her perspective.
Thank you, Zabrina. I'm Arielle Reisman, Senior Social Worker at East Bay Family Defenders. Like Zabrina said, I've been with EBFD since it opened in September 2018, a little before that actually. And doing this work over the last 3 years, I've developed some strategies for building relationships with clients, integrating myself into the legal defense team, and also strategizing how to achieve client-oriented case plans. And my hope today is to just share a little bit of that with you, some of the approaches I've learned that have been effective for me. But I also just want to say, I want to acknowledge that every state and every region and county is so different. And what I'm sharing, not all of it may be relevant or apply to you. So please just take what feels helpful and meaningful to you and feel free to discard the rest. So just going to jump right into the beginning. When I first get assigned a new client, the first thing I want to do is orient myself to their case. I think it's really important to recognize that the work that we do with clients doesn't happen in a vacuum. We do a disservice to clients when we ignore the case history or case status, the legal objectives, the timelines, as well as the department's perspective on what's happened or what needs to happen moving forward. I think in order to later collectively or collaboratively develop a case strategy with the attorney, the client, and when appropriate, the county caseworker, and make decisions about how to move forward, we first have to understand the larger legal context that we're working within. So before I really dive into talking to the parent directly, I'll read through, of course, as I'm sure you all do, the relevant reports and the case notes, and sometimes that takes a really long time. So if I want to quickly get a snapshot of what's going on in the case, I found it very helpful to ask the attorneys to include some very specific information in the case referrals that they send to me. And that I've listed here in the slide and also in the handout that we've included with this presentation, EBFD's case referral rubric that lays out what information can kind of set the stage, and how it really helps me to orient myself to the case more quickly. Slide, Zabrina. Okay. Once I have an understanding of sort of what's going on in the case, at least I have it, I'm building an understanding of the agency or the department's perspective. I have a sense of what the attorney is worried about based on the referral. I want to talk to the parent, and I really want to start building rapport with the parent as quickly as possible, which can be really difficult. As we all know, many of the parents that we work with, for good reason, don't trust the system to support them and are reluctant to open up to service providers, especially any service providers associated with the system in any way. One thing that I found helpful is to have the attorney provide a warm handoff whenever possible. So especially right now with COVID, a lot of the conversations that are happening with clients are happening via phone because we're not able to meet in person. And it can be really confusing for the parent, you know, who's part of their team, who's not part of their team, keeping track of everybody. So I think, you know, having the attorney be able to provide an introduction, introduce the client to you, you know, as part of their first conversation, really signals to the client that you're part of the legal defense team. And that's, I think, very important in building rapport with the client. I also think it's helpful to be very clear about who I am in my role. And that includes explaining that I adhere to attorney-client privilege, attorney-client confidentiality, and let them know anything that they share with me won't be shared outside of the legal defense team without their permission. And I also like to be clear with them that I'm not a mandated reporter. And I think not being a mandated reporter in this context can also help build trust off the bat with a parent that knows no matter what, they can share information with me and that information will remain protected. I also want to let the parent know that working with me is totally voluntary. The last thing I want to do is be another provider that the parent feels like they have to report to. If they don't want to work with me, that's totally okay. And I let them know upfront, that's fine. And if they change their mind, let the attorney know, I'll be there. You know, they can loop me back in later. But yeah, give them choice around that, since they really don't have a choice about working with the agency caseworker. I will say agency county social worker. I'm just used to saying that because they're social workers in Alameda County. I know that may not be the case where you work, so forgive me if I reference them in that way. I'm trying to remember to say caseworker. I think it's also helpful to repeat often, you know, remind them about confidentiality, remind them that you're part of the legal team, because especially when parents are feeling really overwhelmed in the midst of a pretty traumatic experience, they're likely not going to integrate information in the same way they would normally. So, you know, making sure if I'm sensing there's any confusion, just really explaining it again and again, that and let them know that they can always ask me if they have questions about it. I think it's helpful too to also name with the parent up front, like it, you know, I don't expect them to trust me off the bat, and trust takes time to build. And also we do have court timelines that we're up against often. So I might say to a parent like, hey, I know we just met and you may not trust me right now. That's completely understandable. My goal is to earn your trust over time. And I'm also holding that the reality is we have a court hearing coming up next week. And if you're open to it, I would love to support you in doing A, B, and C. And I think that brings me to the next bullet, which is, you know, getting active. I think doing A, B, and C can be really helpful in building trust, because doing things in support of the parent, that provides opportunities to follow through on tasks. So naming what you're going to help do and doing the things in a timely manner, I think can go a long way in relationship building, especially because a lot of the parents we work with have not experienced that before with a lot of the providers that they've worked with or been mandated to work with. And lastly, getting curious with the parent. I think, this sort of brings us to our next slide about assessment, but getting curious about the parent's experience can help really build rapport with the parent, especially when you open it up to hear what they need to say, hear what they want to tell you when they maybe haven't been asked much about what their experience has been, and listening in a non-judgmental, empathetic, and supportive way. And it's the first step in sort of developing our assessment of the client. So I might say to a parent, like, I've read through the reports, and that's one source of information and it's helpful, but I know that what's written in these reports isn't always 100% accurate. It's one perspective, and it may not reflect how you experienced, the opening of this case. So it's really important for me to hear from you what happened. And again, that's where the assessment begins. So we can switch to the next slide. I think assessments are best done sort of over time with parents. I never have a parent come in or meet with me and sit down and do a formal biopsychosocial assessment. I don't think that's great for rapport building with the parent. But I think a lot can be gleaned from having many conversations with parents over time, letting them know if you ask a question that's potentially triggering, or they don't feel comfortable answering, they don't have to, and just giving parents space to open up when they feel comfortable. And I think really exploring sources of strength for families that are often overlooked or misunderstood can be really important. Our assessments at EBFD generally cover the biological, psychological, social, and spiritual aspects of the parent's life. And I'm not going to go too in depth into all of that, because I imagine most folks here are familiar with biopsychosocial assessments. And I've also included a handout that I use. It's an assessment handout. I use it to train the social work interns at East Bay Family Defenders. So hopefully, that's helpful reference for you if you're interested. But general topics I cover when talking to a parent are health, addiction, trauma, and identity. And I wanted to share with you all some questions that I find myself asking parents frequently, which are, tell me about what was going on in your life when this child welfare case was opened. Tell me about your family. What family dynamics do you enjoy? What family dynamics are challenging for you? How would you describe your relationship with your children? How have you already tried to overcome the challenges you've faced? How do you usually cope during hard or stressful times in your life? Can you describe your spiritual belief system? Are you connected to a spiritual community? What aspects of your identity are important to you? Have you ever experienced discrimination as a result of your race, ethnicity, gender identity, sexual orientation, or cultural beliefs or practices? And then the last one I want to share is one that I ask quite a lot. Who, if anyone, do you consider to be part of your support system? Is there anyone you can turn to in a time of need or crisis? And this one is particularly important for us here at EBFD because as somebody who's not a mandated reporter, when a crisis arises, we want to know who's in this parent support network, who we may have permission to reach out to and include them in any safety plans that we would create for that parent. Okay, you can go ahead and switch slides. We've also included a slide here just to highlight some of the more case specific questions we might ask in our informal assessments of parents that help us determine whether the case plan that they have received is appropriate and achievable. And we like to try to do this before the train gets too far down the track. So earlier on in the case, the better. Okay, so like I said earlier, throughout our assessment of the parent, we always want to be noticing and documenting a parent's strengths. And it's helpful if you can frame those strengths as protective capacities, since the department and the judges are going to want to know how that parent has been or is going to be protective of their child or children. And there's a description of protective capacities that was included in the ABA Child Safety Manual, a guide for attorneys and judges, that I reference pretty frequently in my work. It describes protective capacities as cognitive, behavioral, and emotional qualities supporting vigilant protectiveness of children. So cognitive protective capacities refers to knowledge, understanding, and perceptions contributing to protective vigilance. This has to do with the parent recognizing that they are responsible for their child and recognizing clues or alerts that danger is pending. And parents can demonstrate cognitive protective capacities a number of different ways. Just some examples are articulating a plan to protect the child, understanding caregiving responsibilities and tasks, accurately perceiving reality, accurately perceiving the child, being self-aware. Behavioral protective capacities refers to actions, activities, and performance that result in protective vigilance. And parents can demonstrate it, again, in many different ways, but some examples are having a history of protecting others, setting aside their own needs in favor of their children's needs, showing adaptability and assertiveness, using resources necessary to meet their child or children's basic needs. And lastly, emotional protective capacities refers to feelings, attitudes, and identification with the child and motivation resulting in protective vigilance. Parents can demonstrate emotional protective capacities by meeting their own needs, emotional needs, showing concern for the child or children and the child or children's experience and is intent on emotionally protecting the child or children, and prioritizing the children's emotional well-being. So if I can frame the parent's strengths that I'm noticing as I'm, talking to the parent, completing an assessment, frame them as protective capacities for the attorney, that is really beneficial to the attorney, who then will go and use that information while advocating for the parent in court. The other thing that I really try to pay attention to as I'm completing the assessment of the parent is similarities and differences in the county social worker's assessment, the attorney's assessment, the client's assessment, and my own assessment of both the presenting problem and how best to address the presenting problem. So I'm basically trying to map out these 4 different assessments and notice where they're aligning and where they may be diverging a bit, and bringing some curiosity to the differences and considering what approach is needed, if any, in light of these differences. So we can go to the next slide, Zabrina.
And this is where I will jump in to illustrate where we take case strategizing when an attorney is working with a defense social worker. And so as we were preparing this, we're sort of, pointing out that the initial 4 or so slides of this presentation are really about the gathering of information, the assessment, the relationship and rapport building with clients. And then where then the case sort of takes a corner is then figuring out how are we going to now strategize and move forward. So this is sort of where the rubber meets the road. I have found it really helpful for as an attorney to hear Arielle articulate this piece about the misses that again, these 4 perspectives of the department, the client, you as the social worker, or you as the attorney, those 4 perspectives, and where people might be seeing the issues somewhat separately or differently. And far from that being a problem, that can often be an opportunity. And I think the best way is to approach that as an opportunity to be able to look at where are these misses happening and why, and then how do we proactively engage with that as a defense attorney and social worker together. So we really, with Arielle's guidance on kind of again that ABA child safety manual for judges and attorneys is really, really helpful to look at. It's about page 99, I think, in that, right, Arielle, page 99 in that,
really
that document. We do recommend everybody purchase a copy from the ABA. And so what we look at again, there's kind of 3 areas of misses. So one would be if there's a service miss where the department is wanting something to be done and that's not fitting right with the client. And so the process that we recommend going through, we found helpful to go through as attorneys and social workers in our model, is to take a look at what is going on with that service miss, right? And is it a straightforward matter of just advocating with the caseworker for individualized or culturally appropriate services? Or are we dealing with something that maybe is kind of harder to tease out here? And so this can kind of get into both of the categories of a service miss, which might also be due to a miss in perception of the parent's capacity. An example that I have found really helpful from one of Arielle's cases was where there was a client who had some cognitive delays. And, not something that was so obvious that the department would necessarily have become aware of it, and not something that would have been beneficial to the client to have really put a microscope on, but in fact, something that our team noticed and wanted to make sure to support the client around. And so in that scenario, the way that we strategized was to bring forward a specific accommodation or need that would be helpful and responsive for that parent, which in this case was about transportation assistance. And because our team identified that there was a miss in what was happening with the visitation. And when we looked at what was going on, we noticed that the parent was having this real barrier, which sort of couldn't be easily understood by the agency. And so we advocated for a particular type of housing assistance that literally got that client over the barrier and was able to achieve better visitation with their child. So, other misses in perception around parents' capacity could be where maybe where the department is very aware of a parent's, say mental illness. And maybe the parent themselves is still grappling with that mental illness. An example that I've had in my practice was representing a mother who, incredible parent, accomplished artist, developed schizophrenia in her middle age. And it became more and more deteriorating. And her statements of delusion and hallucination were, of course, very alarming to the Child Protective Agency. And, things she said or did made it into the report and sounded pretty prejudicial, pretty damaging. The social worker in my practice at Brooklyn Family Defense who worked with me was able to help me figure out sort of what was going on with the client's schizophrenia. We developed a very close working bridge with this mother's psychiatrist. And we essentially created a team of support for this mother as we were helping her with her miss where she could not understand. She was having such a hard time grappling with developing schizophrenia to this degree. And it's a symptom of the disease or illness to not be able to have that insight or perspective. And we were able ultimately to strategize with her around the pros and cons of certain decisions in her case, which namely was whether or not to go hard and litigate initially, which she really wanted us to do. Whereas we knew that she had just started on medication and that she needed some time for that to take effect, and that waiting until those meds took effect would therefore put her in a much better position and create a much better record in court for her than were she to have gone front forward and put everything before the judge while she was still actively, not lucid. So what that was around this, again, like, what do you do with that? Do we litigate? Do we not litigate? Do we try to seek out more information from providers? And those are key decisions to be making, ideally with a defense social worker or by the attorney's side. So then the next part is about misses in perception of safety risk, which of course is a crucial piece here that we see. And an example I can think of is where there may be a parent who we represent who is attempting to leave a domestic violence situation. And that parent, from our perspective, may be making very wise, prudent decisions, and may also be in the midst of some impossible decisions. And sometimes what we have experienced is sort of a lack of understanding or a lack of sometimes patience with the parent as they navigate these very difficult life circumstances. And so sometimes we will experience the department taking an overly protective approach or an overly suspicious approach with a parent who, from our angle, is actually making very prudent decisions in the interest of protecting their child. And, an example, sort of a regular example might be if the mother has left a home with her children and goes back to get some belongings, and then maybe something happens there that she didn't expect. And so that can often be held against the mother as an example of poor boundaries, when actually she may be putting in place dozens of other terrific boundaries and had this one unfortunate situation. And so in that situation, we have strategized about what are the ways that we can be developing concrete action items and also articulating those to the department or agency so that they can see that the parent does have a safety plan in place, that be a really well articulated safety plan. So this is an area where Arielle's expertise and specialization has, I think, gotten very detailed and supportive for parents. And we've seen the benefit of presenting that to the agency or department in CFT meetings or other kinds of case planning meetings. And other situations where basically the parent could have an opportunity to demonstrate their boundaries. So we hope that gives sort of a flavor of how to really create this kind of defense team together.
Okay, so this can happen with a parent present, or maybe it happens that the social worker meets with the attorney first and then the parent and then back with the attorney again, but this is all kind of happening simultaneously. So let's say you've met with the attorney, you've strategized around the case and what the attorney thinks would be best way to move forward. And then we want to discuss the strategy with the parent. So again, it's helpful to have the attorney present for that. That's not always possible, but I would say that's best practice to have, because they can have input on, whether a specific strategy, how that would pan out in court in front of a particular judge, or they may be more aware of, timelines or, some the legal aspects that they can bring in. But if they're not there, circling back to the attorney is what I do. And I think when meeting with the parent, you really want to directly address the misses when it's appropriate. So the differences in opinion between the parent and the agency or the department, regarding the parents presenting need, risks to the children, or needed services. And what this looks like a lot in our practice is, we get a lot of cases that come in with allegations of substance use. And the parent will say to me, like, I don't have a problem with drugs or alcohol. And I want to respect that, that's where they're coming from. That's what they're telling me. But it's my duty to be transparent with them about what's going to be a potential problem for, the agency and the judge. So I might say, I hear you saying to me that this is not an issue for you. And I respect that. And I want to honor that. And I'm also holding that in this report, it says there's one positive test, and your daughter reported to the caregiver, who reported to the social worker, that she witnessed you using in the home. These are things that we're going to have to figure out how to deal with. So let's think about what you're willing to do to sort of mitigate these concerns. So holding both of those things, but just being really honest with them about what problems we're going to come up against if we go hard, like saying this isn't an issue. So that's one approach I like to take with parents. I also, I think it's really important to spend time discussing with the parents what services actually feel helpful to them, what a helpful case plan looks like to them. How do we tailor how do we tailor a case plan to set the parent up for success? And that will involve, that may involve many different types of strategies. One strategy could be combining services. So maybe instead of having the parent do a DV class and individual therapy, we can advocate for the parent to address the intimate partner violence they experienced in their individual therapy. And that, I think sometimes we, aren't sensitive enough to the fact that parents have so much going on. Maybe they're working 2 jobs, it takes them forever to get from here to there. They're just juggling so many things. And so if we can combine services, if the parent's feeling really overwhelmed, we should advocate to do that, and they're still getting the support that they need. Another strategy might involve completing services simultaneously. So let's say someone goes to inpatient treatment, where they also offer parenting classes and anger management classes, so they can do it all at once. Another strategy might involve doing services one at a time. Again, if a parent's feeling really overwhelmed, overburdened, as long as sort of the timelines allow it, we can advocate that a parent do a parenting class, complete that before being referred to the next service, if that feels helpful and supportive to them. There may be times when we advocate to substitute services or interventions. An example of this that I can give is I was working with a father whose case came in last summer, 2020, after he experienced a mental health crisis that was brought on by a number of different factors, one of which was that when COVID hit, he started rationing his insulin because he was fearful about having access to his medications. So that was one piece. Also, the murder of George Floyd was very triggering to him because he had experienced police brutality himself, had been a victim of an assault by the police. And he also had sort of a falling out with, and this is sort of related to COVID, but a falling out with somebody who was really, really important to him in his life. So all of these things were coming together. And he has a 2-year-old son who he was taking care of full time. And his mental health declined, and he wasn't taking care of his body. So part of this father's case plan was individual therapy. but the agency also wanted him to do a mental health assessment, like a psych eval. And he was terrified of doing the psych eval because he was worried that if he did it, they'd tell him he needed to take medication. And he adamantly was against taking it. He did not want to take medication. So he and I and his attorney got on the phone and we tried to strategize what to do about this. And what we ultimately did was come up with a mental health crisis intervention plan where we like clearly laid out what were the warning signs that led up to this mental health crisis. You know, he wasn't sleeping, he wasn't eating right, he was experiencing specific emotions and feelings. And then we came up with coping strategies. So if he were to ever feel these things again or notice this going on with him, what would he do? He would go to his doctor. He would make sure he was monitoring his insulin. There were all these things we listed out. And we said to him, like, okay, I think you should do this psych eval. We got to move things forward in the case. And if they push really hard for medication, we can present this as a potential alternative to show the court and to show the agency that you are taking your mental health really seriously and you have a game plan in place if anything were to happen, to ensure that your son would be safe. And so he went forward, completed the psych eval. Medication was recommended, but we at a CFT presented this mental health crisis intervention plan, and the agency felt satisfied by that. And medication truly did not come up again for the rest of the case. And his mental health had stabilized quite a bit in sort of taking care of his body and going to regular therapy and other support groups. So he was doing really well. But I think just developing this other sort of intervention or strategy in place of an intervention that he was really uncomfortable with was very helpful. We want to make sure services are culturally appropriate. Often clients don't feel comfortable going to speak to a therapist and would much rather go talk to a pastor. That's something we can advocate for. We want to make sure services are trauma informed. So an example of this is we know that intimate partner violence goes hand in hand with substance use. We see that a lot, both of those things together. And often the treatment that's recommended is residential treatment. And that can be great for some parents, and for others, being in a residential setting after you've experienced, abuse at the hands of your partner, can be really triggering being in this controlled space. So maybe we advocate for outpatient treatment and therapy or some other sort of domestic violence support group, and that can be a better fit for the parent. And lastly, we just want to make sure that the services that have been included in their case plan are accessible to them. So making sure that they're able to get there, that they have the transportation that they need, and when available, advocating for the service that's closest to them. So Alameda County partners with various different providers that do testing. And sometimes a parent will get referred to a testing center that's much farther away and there's one closer. And it's just, a matter of letting the worker know, like, hey, do you think you could actually submit a referral over here? And it makes the parent's life so much easier. Okay, so once we've sort of identified, the ways that we may want to modify a case plan, we try to determine how we want to move forward in advocating for that. So it could look like the parent just talking to the county caseworker, and advocating on their own behalf. Maybe they don't feel comfortable doing that because their relationship with the worker is fraught for some reason, and they prefer me or the attorney to reach out. I think another great place to advocate for a more client-centered or tailored case plan is in child and family team meetings. That's what they're called here in Alameda County. I'm sure you have them, but I don't know what they're called where you work. But basically the meetings that are organized by the department or the agency when they're developing a case plan or a child's being moved or something's going on in the case, they need to get everybody together. I think those can be really great opportunities to advocate for getting the parent what they need. Okay, so I think whenever possible and when appropriate, right, with the permission of the parent, collaborating with the county caseworker can be very helpful. I, just to be totally transparent, have in Alameda County have come up against some amount of resistance to collaborating with them. I don't know how it is where you all work, and I hope there's more collaboration going on, but here it's been a little bit tough. And I think that in large part is due to them not really understanding my role and not knowing why, you know, because they're social workers, not knowing why there's another social worker in the mix. And I think sometimes they feel suspicious of my intentions and worry that maybe I don't care about the safety of the child or the family, or that I'm there to monitor them in some way and then report back to the attorney. So I think it's helpful for me in building relationships with the county caseworkers to just acknowledge off the bat, like, yes, I am part of the legal defense team. And sometimes that means that information sharing only goes in one direction because I'm bound by attorney-client confidentiality. I think it's helpful to acknowledge too that my relationship with the parent is inherently different because I have a duty of loyalty solely to the parent, while the agency or the department has the responsibility of holding multiple perspectives since their client is the family. I think it's helpful to name shared goals, which is often to reunify the family and to support the family to thrive. And I try to encourage or invite the social worker to loop me in on meetings or to call on me for help whenever they need to. Sometimes I don't think they think of me as like a helpful person, but to them, but I think the more I've been able to collaborate with them, that's changed a bit. And I think inviting me in can help increase client engagement to some extent with the worker. Often when there's like a breakdown in communication with the parent and the county worker, I do a lot of coaching with the parent around like, you know, what may be coming up, how to manage those feelings, and also stressing the importance of regularly communicating with the county worker. And then I can also, to some extent, or I try to help increase client engagement in the case plan. And, you know, I can give an example of a time that I did this successfully. It was the same parent, the same father I was telling you about earlier, who was worried about the psych eval. Later on in his case, things began to stall related to visits because he was so worried about the agency coming to his home to do a home assessment. It had nothing to do with the worker specifically, but just anybody from the agency freaked him out. And he was so worried that they were going to come in and tell him all these things were wrong with his house and he was going to fail, like he said, fail the home assessment. And so the worker reached out to me and said, hey, you know, I'm trying to figure out what's going on with dad. We've had the home assessment scheduled. He keeps canceling right before. Can you talk to him? Like, I'd really like to move to unsupervised visits in the home, but we can't do that until this home assessment gets done. And I was like, thank you so much for telling me. Yes, I'm going to call him. So I called him heard him out. He felt like it would be helpful if I were able to identify the things that she would be looking for in the home so that he could have some peace knowing like what it was she was going to come and assess specifically. And then also I offered to be present for it, and the worker was like really open to that, which was amazing. So with that, he was like, okay, I'll do this assessment. You'll be there. We kind of know what she's going to be looking for. And it happened. Everything went smoothly. It was fine. And then he was able to have unsupervised visits in his home moving forward, which got him ultimately better visitation orders and custody orders when the case closed. So that's just one example of ways that collaborating can help, move things forward in the case and are in, client's best interest and the family's best interest. And those are all our slides. So we wanted to leave some time here at the end to open it up for questions.
And I'm just going to interrupt quickly and just say that it is 1:27 if people need to get off at 1:30, but we are going until 1:45. So feel free to stay for questions and answers. So go ahead, guys. Thanks.
Yes, thank you very much, Andrea. So I'm going to stop sharing the screen. I think you all were provided a copy of this in the packet of materials to you, so you can take a look at the PowerPoint as well as the illustrative materials that Arielle put together. So, I think there were a couple, we can have some discussion now, and I'm going to just pick up on a thought or two from the chat and then mention another thing that we had on our radar. And I do invite other folks who have things on their minds or reactions to go ahead and enter those into the chat. That would be great for us given the high number of people here. So first we'll turn to this issue around not being mandated reporters. And so we wanted to share our perspective and experience with that and invite other questions or thoughts about it. So, I think one thing I was thinking about as Arielle was presenting the last slide was that we can never underestimate the importance of parents feeling sort of the steady hand of accompaniment during this very stressful experience and sometimes traumatic experience, often traumatic experience of being separated from their children and subject to the watchful eye, the watchful gaze of the state. And so even with best of intentions, that trust for parents is really hard to build. That's a theme that we hear a lot from our parent advocates in particular who are on our staff, that they are ever mindful of from their own experience and also in their daily work, mentoring and accompanying parents currently through their cases. So for us, the principal decision for social workers and parent advocates to be part of the attorney-client relationship and therefore be subject to the attorney rules of responsibility and ethical requirements of being an attorney were really important for us for our model. We attorneys do find those ethical rules to be pretty sacrosanct. And they allow in our field for the ability for clients to, with greater security and trust, sensitive information to attorneys without fear of being punished for sharing. And so we also have found that in terms of us upholding trauma-informed principles, it's really important for us to be transparent with parents, to be reliable with parents, and to ensure that parents, to the extent possible, have some sense of control or autonomy about how their information is used or not, and their ability to have agency in their case. And so, we in California do have some case law that gave us the reassurance when we were bringing Arielle onto staff and our founding staff of having a social worker that we ensured that that she indeed could be exempt from mandated reporting. And we do encourage legal offices to do that wherever possible, both because of the trust building that is allowed with clients, and also so that there's no threat to the attorney-client ethical responsibilities, because we would never want there to be a conflict of interest between the social worker and the attorney around honoring the ethical rules that attorneys are bound by and that clients should benefit from. So those are our primary reasons. And I don't know, Arielle, if you want to say anything more about what that's been like. We've definitely had situations where Arielle has, wondered if it was a situation of reporting, and we have, spent a lot of time then working through what was happening and figuring out with the client and their support system what was the appropriate and safe way to handle that situation. And I would say that one gift of it is being able to experience sort of a bubble of what would it be if we lived in a society where we didn't have mandated reporting? What would that look like? And there's been increasing talk about the safety net that communities can provide with each other without government intervention. And I would say that we get some glimpse of that in our practice. Arielle, do you want to add anything?
Oh yeah. So yeah, it's interesting. I think I found in my work that the moments I might in another context report something, or when I'm worried about the parent potentially harming themselves, not much has come up in the last 3 years, at least, that have to do with me feeling really worried about the safety of the child specifically. But yeah, so in those circumstances, it's just a lot of safety planning. It's not that we don't do anything, but our intervention looks different. We're creating safety plans, trying to loop people, support people in who can be there, 24/7, not just providers, but also linking them to, whatever providers may be helpful in those moments.
Does anybody have any other questions or thoughts about that, or questions about anything else that we've covered today?
I think I'll share one other thought then. What came up in our planning with Leslie was the concept of whether or not there were ever two case plans or a shadow case plan. And we wanted to talk about that a little bit from our experience. We have, first of all, found it really helpful to make sure that we're not duplicating case plans, and that we're really keeping things focused on the case plan developed by the department, and that any modifications we're doing are really squarely to grapple with the department's case plan for the parent or the court-ordered case plan. And really making sure that the parent has agency and voice and influence, so that that case plan is actually really responsive to what's actually going on for the family and will actually be something that could be transformative versus hoop jumping. So that's something I think we all kind of know, but one element that we have, been looked at or been experienced is that sometimes we may literally have like a shadow component of the case plan that might be something that we hold confidentially with the client. Again, if there might be something more sensitive that is not something that, neither the parent feels comfortable sharing more broadly with the system, or might not be appropriate. Say they experienced a particular type of trauma in their life and it's not relevant to their, care for their child. However, it's getting in the way of their own ability to trust or engage in a service or something like that. And so we may have, I would sort of just say, like a shadow component that we hold that is a companion to the case plan, where there may be an additional service or an additional kind of approach that we are handling honoring again that more confidential relationship with the attorney and defense social worker that will then put the parent in a position to be able to better achieve the actual case plan. So if that kind of makes sense, that we always make sure that we're not just duplicating the system. What we're doing is really helping them achieve the goals and exit themselves from the system successfully so that they don't have to be system involved ever again, right? So we always try to keep that. That's our way that we reconcile what service planning we would do.
If nobody else has a question right now, I also, Zabrina, wanted you to talk a little bit about kind of the whole strategy thing when thinking about invoking the ADA. Because it's a tough one. If it's going to advantage your client to have the accommodation, or if it's going to disadvantage your client by sending the message that they're not able to manage, their kids on their own.
Absolutely. I mean, I think that is a great also context, Leslie. Thank you for putting it in the context for attorneys of when we might want to actually create an ADA argument or launch an ADA argument, which in general for, everyone present, especially the attorneys, I think that is really crucial for us to be moving forward in this field. We've seen some progress in other states with getting the ADA to be considered relevant and to apply to the child welfare law. And there has been some recent federal guidance that paves the way for that to be included more and more in the legal analysis in child welfare. And while we're doing that sort of legal argument, and we may want to be invoking those arguments that the system should be making accommodations for parents with disabilities rather than terminating their rights based on those. Indeed, we have run up against this very issue, especially with parents with mental illness, where they may not want a diagnosis at all, right? And that may feel very disempowering and labeling for them. And even putting their mental illness front forward that way may feel very wrong to the parent. Whereas from the legal perspective, we could be thinking this is what would get the mercy from the judge to apply a better legal standard for them. And so in that situation, obviously we are guided by, what the parents, willingness is to be able to invoke those kind of arguments. I would say that, what we do really try to focus on is those conversations with the client, both with the social worker and with the attorney, and ideally joint meetings, as Arielle was emphasizing, with the attorney and social worker, both with the client, to be able to have not a ganging up experience, because of course they're going to feel once you've got those trusting relationships, to be able to sit down together and just look at the issues together and say, here's what we're seeing, and you're really in the driver's seat, parent. So, tell us what you want here, and these are our concerns. So.
Thank you.
I think we talked about it a lot already, but we don't have that situation where our social workers are not mandated reporters here.
Mm-hmm.
And so I think this concept or this idea is interesting to us, because I know that I can't speak for the social workers. I know that they have their own ethical guidelines, and we don't want to step on their toes either. So I don't know if any of our social workers might want to talk about that. I saw Susan, you turned on your camera. I wonder what your thoughts about that are.
Hi. Well, I was thinking about that too. I don't know what to think about it, except I totally understand the benefit of the work, why that would be beneficial, how that would even likely increase the ability for clients to be participating and somewhat trustworthy. It's true. We have not trustworthy, but with that word trustworthy. I mean, the social work, national license is what it is, and there are specifications of being mandated reporters or reporting abuse. But that's also a legal issue. That's a legal mandated reporting is done by state, I think. I mean, not that I'm a lawyer, but so I don't know. That's something I think that the state of New Mexico at the legislative area would have to be one who does or does not require mandated of whom. In New Mexico, it's everybody. Everybody in New Mexico is a mandated reporter. Now, the issue of obviously the lawyer situation changes that dynamic legally. So I think that the best case scenario that we use, that the social workers, I'm a clinical consultant for the program, and I'm not a social worker in the program, but I'm fully aware of it and know them. The transparency is enormous. And I think the issue that I heard Arielle talk about was being able to articulate the misses. And if the misses is that what they have, that's totally wrong. I did not do that. Then all you can do is go to what can we do now? Because they have the decision making, not us. So what are we going to do to make it possible for you to satisfy them? And so, and one of the truths may have to be that we are tiptoeing on the edge, dear client, on mandated reporting for me, right? And so we have to be able to explain and talk about what's going on in a way that I'm satisfied that I need to fulfill my obligation. So I know I'm talking a lot, but it is probably one of the grayest areas, but also probably the most one of the most powerful areas in the program.
Yes. I really appreciate all of the nuances that you're bringing up, Susan, and that we're unfortunately in this situation where the professional guidelines or obligations of the fields are in tension, right? I mean, attorneys are expressly not to reveal information except in a very limited perspective where they might have the option to do so. And that for social workers, the mandate is so broad in terms of actually being mandated to report. And so there was a question in the chat about would they have to be under the supervision of an attorney. And so it's sort of not as easily answered as yes, that's not really, can't answer that in a yes or no way, right? So what I wrote in the chat, which I'll just explain a little bit, is that that indeed to be part of the attorney-client privilege, confidentiality, loyalty, privilege, those ethical obligations with the attorney-client privilege, the professional does need to be considered an agent of the attorney.
Well, and I know in this program, the social worker is considered part of the confidentiality laws, wordage I can't articulate, but it's part of that team. The issue of the mandated reporting is somehow external to all that, to that triangle that you're in with under the guise of the lawyer, there is confidentiality and, but there's the big but, right?
Well, right. And this is why there's been, some emerging guidance around this, because there does seem like there would be a contrast, but our position is that once a professional is is an agent of the attorney and is therefore part of that attorney-client set of ethical responsibilities, then those are the governing legal and ethical responsibilities. And that by nature of being an agent of the attorney, those social workers have to be exempt from mandated reporting, because to still maintain mandated reporting would be in breach of the attorney-client ethical obligations. That's
I'm curious if that's ever been run up to the NASW offices, where those decisions about what is our duty and what is our mandate as social workers, if that's ever been actually expressly discussed with them.
I think that would be a great inquiry and discussion to have with them. What we did here in California is we consulted with the directors of the social work program at UC Berkeley and shared with them the case law that we were following that indicated that social workers who were part of that attorney-client relationship were therefore exempt. And so that was our mutual understanding that we had that governs our program. And obviously, those were important conversations for us to have, and we think are worthwhile for the field of social work to be having. And what I'll say is, I don't know that I even said it as deeply, strongly as I could have at the beginning. Like it's incredible and a complete asset to be able to work alongside defense-oriented social workers in this field. I just, the skill and the perspective that really balances the attorney perspective, and just, those subtle ways of building the relationships with parents and being able to meet them where they are really worth going down this road, I think, to figure out the best structure for it.
Well, it actually opens up the discussion of what really needs to be mandated, what reporting needs to be mandated. Did they shoot up right in front of the kid in the living room? Or did they start doing drug use and you know that they did drug use, which could ultimately be bad, but has nothing to do with what goes on in the home? I mean, so that, one person might say, oh, that is a mandated reporting thing because I know that that's going downhill rapidly versus something else that's clearly, objectively problem. So that's a whole nother larger issue.
Yeah.
I know we're out of time, but
Right.
these things could go on and on and on in terms of discussion, huh?
Totally. When I worked at a youth center where some of our social workers were mandated reporters in a different section, we actually came up with a set of interpretations for our purposes of when we would do mandated reporting or not, and then how we would do it. We had social workers in our legal unit who were not mandated reporters, and then there were social workers down the hall who were. And so the young person could choose whether or not they wanted to go down the hall, and that was, so I just think there is room for figuring this out because you all are the ones with the real relationships and responsibilities to your community here. We don't have to take these things from on high without really engaging with what they really mean and what our duties are to our communities.
Thank you guys so much, Zabrina and Arielle. You gave us a lot of information. Again, your PowerPoint, I think, will be available to everybody to review and go back and look at. I think you brought up this issue of mandated reporting, which is different from our model and something that we really need to think about, give the pros and cons. And so thank you for bringing that up as well. It is 1:48, so we're at the end of time, but I just wanted to make sure that you guys know how much we appreciate you and giving us your time and information here.
Thank you very much.
Thank you, everybody.
Thank you all for
Goodbye.
having us.